Hello everyone. So we are on to chapter 4, which is our last section, our last chapter for this first kind of introductory section. We will be talking today about some administration issues that deal with modalities. So most of this should be review. We're going to talk legal issues and confidentiality and things like that. So hopefully, if you can recall back to other classes, you've heard this once or twice by now, but it's really important to think about it every year and in context because it's a really significant issue, not only as a professional, but also you as a student as you start to use these modalities and be involved in the treatments. So, talking about some legal issues first. So again, most of the words on the screen should be familiar in one context or another. First aid, intro class, techniques, now here, med topics. We've kind of hit it a lot. So first thing we're going to talk about is scope of practice. So scope of practice is really based on the idea of what is it that the athletic trainer is allowed to do. And scope of practice is usually set by state regulation. So here in Minnesota, we have registration and we have a state practice act. And that practice act dictates what athletic trainers are allowed to do under their title, their name as an athletic trainer. In the state of Minnesota, part of that registration is actually to have what's known as a protocol. And that protocol is a form between you and your supervising physician. So like me and Dr. Fetzer, and it says kind of how long I'm allowed to treat an individual before they need to be reassessed or seen by Dr. Fetzer or another healthcare provider physician, the type of treatments that I'm allowed to perform, kind of in general what my care looks like. And so we renew that every year. So that states my scope of practice. And that becomes kind of the stamp onto which any sort of legal issues, especially negligence, is held to. So when we start talking about determining negligence, they're going to go back to the scope of practice, and in this case in Minnesota, the State Practice Act and my protocol, and dictate what my job was supposed to be and if I followed that or not. The whole idea of the scope of practice is really about protection of the public. So it's setting up this idea that the public should be able to know who's qualified and who is not qualified for their care. Other things that go into the scope of practice are things like professional practice statements. So in our case, that is most often like the NATA position statements. When your professional organization comes out and states, these are our best practices, that's going to end up being used as a definition within your scope of practice. And even to kind of a smaller level of your individual job description, okay, and what that states, who your patient is supposed to be, what your role is supposed to be, as well as the policy and procedure manual for your institution. And that policy and procedure manual should obviously be aligned with state practice acts and standards of practice and scope of practice. Next up in this conversation, we have medical prescriptions. And, you know, from our everyday life, we think of prescriptions as medications, right? You go to the doctor, you get a prescription. But really, a prescription, a medical prescription, is anything that a physician dictates that you are supposed to do during the course of your care. So in most cases, that means, again, some sort of medication. Surgery would be a prescription. In our world, that can be the referral, okay? And so some state regulations, some state practice acts require that a physician directly refer all patients to an athletic trainer in order for them to have care. Other times it could be that they require physician's direction for care, and that's more of our protocol type situation in the state of Minnesota. We're allowed to see our patients under our scope of practice up to, again, that certain amount of time until we'd have to refer them if they're not better or, you know, have decrease their disablement by that point. There is this idea of a direct access professional. Those are individuals that can work without a physician direction. Okay, so again, this is state to state, but like a chiropractor is a direct access professional. They don't need a referral from a physician in order to do their job. In some states, athletic training is a direct access. In other states, it's that you need that referral. And in like our state, we just always are working under the direction of a physician. And so that's considered the prescription. Physical therapists, that was part of why they went to the DPT, the doctorate level for physical therapists, is they wanted to be able to be direct access. Even with that, being able to be direct access does not always mean that that's the mechanism you get. So a lot of patients still get to physical therapy because they get a prescription from their physician. Others will just kind of make an appointment directly. So again, it depends state by state and by profession. One thing to note is if you are in a situation where you're potentially eligible for third-party reimbursement, right? So an insurance company could reimburse you for your services. They often will not reimburse unless there is a medical prescription. And then that even gets tricky of, well, what is the prescription and is that something we allow and things like that. Another thing with the medical prescription is if you do get referred a patient from a physician and they have a strict protocol, a specific protocol for how they want that treated, we have to follow that unless we have written or verbal agreement between us, the physician, and the patient. So what that means most often in our realm, so think about collegiate athletics, if your patient maybe had surgery not with your team physician, so not with Dr. Fetzer, and maybe it was over summer, right? And so they were getting physical therapy, they had a prescription from the physician with that, and now you're being referred that patient essentially from either their physician or their physical therapist. And if they have a set protocol that this is what they want to follow post-surgery, you have to follow that. So it might not be what you typically do, it might not be what your team physician does, but that protocol, that prescription takes precedent. If you do not have direct access capabilities in your state, or if you're not allowed to just work under the direction of a physician, if you actually need the individual prescriptions, then usually for sure you need those prescriptions in order to do a lot of the therapeutic modalities. That's usually the biggest area. You can usually still evaluate and potentially recommend activities, therapeutic exercise, but to do modalities, that almost always needs a medical prescription or being working under the supervision or kind of direction of a physician, or in our case, having a protocol that allows that. Now, obviously, if you're doing a modality that actually uses a prescription medication, so an example or two examples that we have that you'll learn is iontophoresis, which is using e-stim to deliver a medication, or phonophoresis, which is using ultrasound. Both of those, because it's a prescription medication, you need a prescription from a physician to that patient, okay, in the patient's name to get the medication and to be able to use it. There are things that are called blanket prescriptions where a physician could potentially write a script for that med for the facility. Many states do not accept that because it's in violation of the state pharmacy practice acts. You'll talk more about medication regulation and so on when you get to drugs and sport, and we also talk about it in leadership class as well. So on to informed consent, okay? So as you know, informed consent is where we get permission to treat. And it's not just permission to treat, that informed piece is really important. It's about educating your patient on all the options available. And, back to kind of our evidence-based practice idea, like what is available, what are the contraindications, what are the indications, what's going on, so that they can make an informed decision on their behalf. If you do not get informed consent, okay, and you touch the individual, that is actually battery. It's unlawful touching. So any touching without consent. Potentially, negligence could follow from not getting informed consent as well. We'll talk about negligence in the next slide, but the key with negligence is there's things that you have to prove, and one of the things you'd have to prove is that there's actually harm that occurred from the non-consented care, the non-consensual care. And so it's a little bit more, but the battery could happen just from the care, whether you did a really good job with that care or not, but because you didn't get informed consent, that could happen. So always want to make sure that you are educating your patient. So when we're talking about modalities, about the modality, the science behind the modality, the sensations the individual could expect, what potential adverse signs and symptoms that would make us want to stop the treatment, right? The things we'd want them to tell us so we stop it. Any other potential hazards, contraindications, things like that. Having informed consent is not an all or nothing thing. So they have the right to say no at any time, okay? Even if you started treatment, or maybe they will consent to one treatment but not another. If you've started treatment and course of treatment, they can say no at any time, and you need to respect that. Them consenting is not a blanket waiver. It doesn't waive their right to sue you for negligence or liability if you don't do a good job. All it's saying is you have the right to actually touch them in this moment. Okay, so make sure you're always getting informed consent. If the person is a minor, you need the legal guardian's consent. And so that gets tricky when you're at a high school. So usually there's an informed consent document that needs to be signed, and then still you should be informing the parents or the legal guardian of the situation and getting individualized informed consent as you go. Final one on this slide is patient confidentiality. So again, the idea that every individual has the right to their privacy and that their medical records are for sure part of that privacy. In order to release any medical information, medical records, we would need written permission from the individual to release that. So usually at the start of a semester, the start of the year, student athletes, for example, will get a blanket kind of release of medical records. And usually that's between the athletic department, the athletic trainers, and like the team physician. So they sign that form so that we can give information to Dr. Fetzer, and he can give information back to us on a kind of wide scale. You might have the same thing between you and your health service, for example, or things like that. It still doesn't mean you share everything. It only means you share things that are important for the continuity of care. And so, you know, if you know something about a patient, does not mean you can just automatically tell Fetzer because you have this this waiver or this direction. You still need to think, does Dr. Fetzer need to know this? Does another athletic trainer need to know this? It's the same thing for among the athletic trainers within care. You just basically don't share anything that doesn't have to be shared. And if it does need to be shared, you need that written permission. And that permission ideally also states to whom it will be released and for what purpose. If it relates to medical clearance for maybe scholarships or thinking about like going pro or other employment issues, then you need to also have that dictated on the release, and that should be a separate release, maybe from the blanket one done. Slander and libel. So if you break patient confidentiality, you're found to be having breached liability, to be liable for the situation. Specifically what's known as defamation of character. So you've probably heard that term around before. So releasing medical records without permission is a form of defamation of character. If you do it spoken, so if you just tell someone else, it's called slander. If you do it in print, it's called libel. So professionals can be responsible for that as well. Within patient confidentiality, there's also this idea that the patient can review their medical records upon request, kind of at any time. So that's something to keep in mind too. If those records have to be removed from the facility for any reason, you would need to state that and get permission for that. Again, what the purpose is, the date leaves, the date it returns, all of that. Another thing under patient confidentiality and medical records is usually like, okay, so how long do we have to keep these records? It's state by state. So you have to know in your state how long you have to keep records. It's much easier now with electronic medical records. It's not that big of a deal to hold on to records. When you had paper files, it was a much bigger deal. It's usually anywhere from 3, 5, 7 years. Different states have different regulations. The other two things on the screen are two laws or acts that relate to patient confidentiality, specifically with athletic training. The first one is HIPAA. We've talked about HIPAA a lot, and it affects past, present, and future medical records. And it's there in place to help control protected health information, or PHI. So it had a lot to do with when electronic exchange was happening and standardizing how electronic exchange occurred, especially between healthcare providers and insurance companies. And it has just kind of exploded from there as far as, well, this deals with any medical records, not just those that are going to health, to insurance companies. FERPA is something that you might not be as familiar with, but you actually deal with that as well. So that's the Family Education Rights and Privacy Act, and that protects educational records. And in the cases of school athletic training, so high schools, colleges, junior colleges, whatever it might be, medical records are considered part of education records. And so those cannot be unauthorized. There can be no unauthorized release of that. So any school that receives federal funding is responsible for following the FERPA Act. An example of this, of a violation of potentially FERPA, would be, so some athletic training rooms have like a paper sign-in sheet, right? You write down your name, the time you got in there, and what you're coming in for. If it actually has what the patient visit intent is, that's a violation of FERPA, because that's out in the open for the public to see, and that's unauthorized. So if you're working in the school system, you have to understand both the HIPAA regulations and the FERPA regulations and figure out that you're following those